Good evening, ladies and gentlemen. Tonight is a regular special meeting of the South Kingstown Planning Board. The date is Thursday, December 2nd, 2021. It is about 4 minutes past 7. The first item on the agenda is roll call. Susan Axelrod.
Here.
Joe Murphy is absent. Paul Jordan.
Here.
Josh Daly is absent. Peter DiStefano. Here. Robin Pothier.
Here.
And Maria Mack is here. Our agenda item this evening is a zoning text and map amendment for South County Hospital. If there is someone representing the applicant and would like to make a brief statement, we have received the side-by-side comparison from staff that we'll be discussing this evening.
Good evening, Madam Chair, members of the board. For the record, as you know, John C. Revens Jr., Revens and St. Pierre for the applicant. With me is Andrew Prescott, who's the general counsel for the South County Health, and Scott Lindgren, who is the project engineer. We received the review of the text amendment yesterday, and we have it in front of us and are ready to discuss it with you as however you see fit, Madam Chair.
And could you just repeat the name of your engineer?
Scott Lindgren. I'm sorry, I'm leaving my mask on. Do you want me to take?
No, that's fine. Got it. Please proceed.
Well, you have the report.
We do. Didn't know if you had any brief initial thoughts or...
No, I mean...
Otherwise, we can just start our conversation, because obviously we have not had a chance to have a conversation in any kind of detail relating to the current regulations and what has been proposed.
Right, I get that. I guess, so we're here to follow it, however you want to handle this, Madam Chair.
Yes. All right. Jamie, would you like to start us off then? And thank you for the larger version of the text.
Madam Chair, if you don't mind, we're going to switch screens here, and I'll be able to put the text up. Again, Madam Chair, I'm just putting it on the screen. I know in all likelihood it is not completely legible to all commission members and given the scale, but the applicant as well as the board members have hard copies of this, but this will at least give you an idea of where we are and on what page we're on.
And I'm not sure if any members of the public can actually read that, but if you move up a little closer, it might make it easier. You don't have any hard copies of this, do you, Jay or Jamie? That would be great. I think everyone would appreciate it, yes?
Yeah, we do have this up on our on the planning department's webpage.
Okay. Did everyone hear that? This text is on the planning department's webpage as well, contained within the town website.
So again, Madam Chairman, you have an application that was submitted by South County Hospital, particularly associated with revisions to the proposed Section 603, Government and Institutional Zone, which the hospital resides within. The information you have for us was prepared for staff at your request. It's in the format of, on the left of the page, you will see the existing text, proposed revisions to that. There's a secondary column in the middle that is a highlight of the proposed text changes and just a brief explanation of what those changes are. And then the third column, the column to the furthest right, is comments from staff. So, with regards to the regulations, the first actual change is on the third page of our handout, and it deals with Section 603C. As you'll note in this section, the existing regulation refers to the submission of a master plan. The applicant has been proposing to change that language to an institutional long-range plan. That's consistent throughout their document, so wherever it's previously referenced as master plan, again, new proposal is to use new terminology associated with that of institutional long-range plan. And again, Madam Chair, what I'd like to do from a framework is as we go through Section C, there's a couple of highlights of the proposed changes and then a few comments. I would prefer not to read each one of those, but perhaps as we go through each section, ask the planning board members if they have any specific questions based on the column and staff's input that you'll see on the right, if that's okay with the board members. So again, that first section is Section C. It regards changing the framework on the definition. It also proposes to change the framework to development plan review. Our primary comments there were one of the primary changes of development plan review is that foregoes the public notice process associated with a public hearing that is mandated in the existing regulation that would no longer be required in the proposed language. I don't know if any of the planning board members have any questions.
I have a few comments on that. To me, this was one of the things that really stood out, in my opinion, as being completely unacceptable. The reason that we have public comment built into our regulations, regardless of what type of a permit or application it is because the public input is so important to the process. And to me, the idea of eliminating notice and true and valid public input is just not acceptable. So as far as this particular item is concerned, I think that if any organization that has sufficient staff and expertise that they hire to do their planning should be able to articulate that. It's, as they have said themselves, a community hospital. They should remain part of the community and be willing to have dialogue with the neighbors. The process that we have now in place has worked for 20-something years, and the hospital, up until this recent ask and change of administration, has been willing to accept the master plan process and work with the town. So as far as this particular element within the request, I'm not at all agreeable to that, but would like to hear from other board members.
Madam Chair, I am 100% in agreement with you. I think the neighbors need to continue to be part of any process of development at the hospital.
Anyone else? Robin?
I think that if neighbors want to bring in expert witnesses, that having a formal panel and place to present that in is important to the presenters as well as making them legitimate.
I absolutely agree that this is vital to keep public comment in a format such as this in this process.
Pete, any? Very good.
Madam Chair, if I may, I will point out that the applicant, in lieu of the formal public hearing process that requires notice, was making a recommendation to have an informal meeting with the neighbors, but there was no process notice associated with that in the regulatory form.
I mean, I always go back to thinking about NEPA, the National Environmental Policy Act, when that was amended in the 90s with regard to federal projects. one of the specific elements that was added was meaningful public input, and I've always believed that that's an important part of any process that we might undertake. So, next section, Jamie?
Yes, Madam Chair, again, the next section revolves around purpose. Again, you have a change in the language of the terminology of the master plan. There is a discussion about adding some criteria with regards to historic resources, consistency with the town's comprehensive plan, and adopted land use policies, or the proposed new language. And that replaces terminology that states that there shall be consistency with, and also it includes a 5-year implementation plan. So again, this section removes the implementation element and the 5-year projection of improvements. You have staff's comments on the right. Again, the applicant is looking for an expeditious approval process through building and zoning. So we're concerned about eliminating the statement regarding compliance with zoning as well as the comprehensive plan and just using the mere term consistency. In addition, any reasonable master plan, long-range plan should include some type of implementation time frame or long-term planning as it relates to any proposed capital improvements. Again, I'd like to make it clear that in any plan that would be submitted to the board or the town, staff isn't looking for a business plan associated with the operational aspects of the hospital, what they're proposing to do with regards to expansion of particular beds or space, but it's really looking at the built environment and what the implications of that built environment are on the neighborhood and internal to the site.
Thanks, Jamie. I certainly agree with the staff comments here as well. Consistency with our zoning ordinance and comprehensive plan is something that everyone else is required to comply with. And although I think that we should be open to a certain amount of flexibility, for example, if you have a 5-year plan allowing more changes within that 5-year period than I think 2 is stated. And as Jamie said, allowing flexibility for changes that are made within the hospital. But compliance with our primary set of regulations, our comprehensive plan, our zoning ordinance, I think is very important. And implementation, I mean, many projects are done in a phased approach. There are often changes, but I think outlining some kind of implementation is not unrealistic. I don't think it's something that they would be held to a very stringent standard if they need to make modifications. I think reasonable type modifications would be warranted.
And Madam Chair, I would tend to agree with you. I would not be adverse to any regulatory changes that eliminates the number and manner in which they're allowed to revise their plan. I looked at similar, if we were sitting here as a planning board within Rhode Island and the state legislature passed a law that said you could only revise your zoning regulations once or twice every 5 years. The hospital is a living, breathing institution. They need to be fluid. They need to be able to react to the marketplace. And in some instances, that could mean the need to amend it 3 times within 1 year because of a changing condition. And I think it's an overly burdensome requirement. And again, if they update it, it could be an update that re-triggers another 5 years. Because if they update it 3 times and everything's valid, there may be the ability to say once you update it in that interim, you get another 5 years before you have to re-update it again. I would not be adverse to that type of language.
So I have a question. I understand the flexibility in the implementation schedule. I'm not sure how I feel about a lot of flexibility in the plan. I mean, if you get a lot of public input on what a 5-year plan looks like, and then it's very easy to change it without going through the same process, is that what you're?
No, it would be
No.
the same process.
Okay.
But because they're going through the same process and you would have that public notice, again, there's an expense, but if they anticipated, pre-pandemic, they may have been headed down a certain path. And then the worldwide pandemic hits, which requires them to deviate from that path. What if they already used up their 2 amendments in the 5-year time frame? Does that mean they can't come back and when they need to be fluid and dynamic with the changes that are both, within the town, regionally, statewide, and worldwide now? So I think, again, there's a process to do that, but I don't think you should be overly burdensome on the number of times they can do that.
And there are other, in addition to the required public process, the hospital does have an ability to do things such as have an open house on a regular basis and have conversations with the neighbors so they are in the loop, so that when they come to the public hearing, they're not surprised and may perhaps actually be supportive. So having a consistent, good dialogue with your neighbors is a wonderful idea, in my opinion. Thoughts from board members on this? Robin?
Well, can I just jump back to Part C's main opening paragraph? And the removal of dimensional requirements, I don't see the benefit to having that in that statement.
Can you explain where you're?
So we're removing which shall be in compliance with the use and dimensional requirements of this ordinance in the town's comp plan?
Well, I think we just said we think it should be in compliance with the comprehensive plan and zoning ordinance. That's what.
Right, and particularly in terms of dimensional requirements then?
That would be
Okay,
compliant with zoning.
Okay.
Anyone else on this? Let's move on to the next one. Oh, go ahead.
Sorry.
Sure.
Do you read, I guess this is for Jamie, a large difference between the word compliance and consistency when it comes to the town comprehensive plan? Is consistency similar to compliance, or do you think that's an entirely separate thought?
I will make a statement, and then if I misspeak, we have counsel here, but compliance with a regulatory requirement means you either meet it or you don't. Consistency doesn't have that standard associated with it. I am consistent with the parking requirements. The question is, do you meet them or don't you meet them?
And Jamie, having the language being in compliance would not in any way prevent the hospital from, as part of a master plan or an update, asking for a waiver, correct?
Correct. And I think to that, I think one thing that potentially is lacking in the language is that dynamic and fluid nature of the campus, that you have a hard and strict zoning code.
Mm-hmm.
It requires X number of parking spaces per square foot. That's taken out of, historically out of the ITE manual, which is the Institute of Traffic Engineers manual. Is taking out of another American Planning Association APA parking 3-ring binder study. But it doesn't necessarily always correlate to the needs of the institution that is bound by that regulation. So again, this regulation potentially could use a section or verbiage associated with some provisions that allow the planning board to waive that hard standard so long as the analysis is submitted to the planning board that supports the waiver they're requesting. They have X number of square feet, and they're, just say they're doing a 20,000 square foot addition, and it requires another 100 parking spaces. but their traffic analysis and parking analysis correlates to a need for only 40. Why would a planning board or municipality require an applicant to build 60 additional spaces, all that impervious surface, the expense, the water quality, the treatment, the utilization of land, if they can prove that they only need 40? Their only ability now would be to go to the zoning board and get a variance. Variance isn't always, holds a strict standard. So I think there's an opportunity to build that relief within the regulations.
Amy?
I agree with what Jamie is saying here, and whether or not this provision of the ordinance, right, whether or not this amendment explicitly states it, all has to be consistent with zoning and with the comprehensive plan.
Thank you. Other thoughts? Continue on.
So the next section is filing requirements, and again, this deals with the transition to an institutional long-range plan, the requirement to update the plan every 5 years, the need for renewal, and then remove some of the provisions associated with the number of times that they can renew. And again, our observation that, again, it removes the requirement to prepare a plan within a stated time frame. And this is, Mr. Revens may have an answer for this, but the existing regulation, when it was adopted, required the hospital to submit a master plan within a certain time period. By deleting this language and not replacing it with anything, I'm not sure when the hospital would have to submit an institutional plan. I want to say the hospital, through a previous permitting process, was probably 95% of the way there on a master plan that they withdrew from the application process. So they may have a mindset that they're absolutely going to move forward in an expedient manner to do their long-term plan, but it would help if there was a time frame associated with that. Again, I don't see any issues with not restricting the number of revisions they can make to the plan, because again, the industry that they're in, the sector that they're in, is fluid and very dynamic, and I think we have seen that over the last 18 months and in fact are continuing to live it on a daily basis.
And, up until recently, our comprehensive planning process, it was a 5-year process. We had the ability to make changes to it 4 times a year, and those changes could then be bundled. So it's a similar situation in a way, right?
Again, from a legal perspective, not a planning expert perspective, I don't think it makes sense to apply the same limits on amendments to a long-range plan that exists in the comprehensive planning statute for a municipality, right? A municipality is very different from a private.
Right. I was just making an analogy to say we should allow them more flexibility with regard to that. Thoughts on that? Okay.
The next item 3, procedures. We touched upon this briefly with regards to the existing process requires a formal public hearing. Because it's a formal public hearing, there are notification requirements. This is their proposed change to that, where they are doing a kind of less formal public participation process, where they would propose to meet with the neighborhood. But again, there's no statutory framework for that. There's no time frame or notice associated with that. So again, I would defer back to these standards associated with a normal public hearing. And again, to my point, if they're basically doing a master plan every 5 years, that's potentially one public hearing every 5 years. It wouldn't negate their ability to hold a public meeting with the neighborhoods, in essence, on an annually basis, biannually, to seek that input to try and circumvent perhaps a public outcry every 5 years because they just don't understand what's happened over a 5-year time frame.
That makes sense to me. Anyone else on that?
The other aspect of this was in double I, a pre-application meeting before the planning board on a new or amended institutional long-range plan. That was left to the discretion of the administrative officer on whether or not we deemed the scope was sufficient enough. And I'm just not sure how you make that call. I mean, I have a good idea how to do it. You know, if they were proposing to, if their institutional long-range plan referenced certain lighting component, and they were proposing to modify the lighting component because a new type of fixture came out, to me that would be very simple and wouldn't rise to the level of pre-application with the commission. But again, that's a very conservative approach. There's probably some areas that may be gray, and conservatively, as an administrative officer, I would automatically kick it to the commission.
You might be able to, if you think this language of significant is too ambiguous, you might consider taking the language on major changes and minor changes from the subdivision regulations, which could potentially provide some guidance for the administrative officer.
That's a good idea.
And again, we're really trying to solidify the process for the hospital so that depending on who sits as that administrating officer, they have a really good idea of what process they're going to be in.
Right.
Versus,
Right.
1 year it's one opinion, 3 years later it's
Exactly.
a different opinion.
Specifics and clarity are always important.
Understanding that you probably won't always be able to remove the black and white, that there will still be some shade of gray and subject to interpretation.
Can I ask a silly question? Are you the administrative officer that's being
Yes.
referred to? Okay. Thank you. Or whoever sits in your chair.
And again, the person who sits as the planning director varies from time to time with regards to qualifications and comfort level. Someone may be regulatory heavy, but not site design heavy, and vice versa. So there will always potentially be a different comfort level with that individual. So the more we can clarify in it, I think the better it is for the hospital.
Yes, and interestingly, that varies from town to town who the administrative officer actually might be.
I think that we need to be protected from those possibilities.
So in saying so, then would you advocate for more specifics or advocate that the pre-application would be required?
Would be required.
Would be required.
I don't think it should just be a single person.
Yeah.
involved.
Okay, I can understand that.
Again-
I am considering Amy's suggestion that we actually, instead of mandating a public hearing for every change, maybe have a listing of things that would not require a hearing, such as light fixture replacement or, just small things that we wouldn't need to bring a hearing for.
I
Again,
don't think
No.
there'll be that many changes going on in every 5-year period that,
but there are standards contained within the subdivision regulations. it doesn't impact X number of square feet of building floor area, doesn't have any effect on parking off-street loading, doesn't result in a significant identified change to the master plan, doesn't increase in intensity or use of the site, no significant negative impacts on abutting property within the vicinity. There are some instances that I could see that they're trying to do something to improve, so why burden them with a 2, 3, 4 month application process for something that can be very simple? And again, so long as the provisions are there and the planning board as well as the hospital comes to some consensus on those criteria, I'm more than comfortable to do that. It takes the burden off the administrative officer, and then the question from the planning board of why did you approve this, and the debate of we don't think it was your authority to. Administrative officers put in a position to say it is, you say it isn't, and who's in the lurch? The hospital.
Right.
So I'd like to also ask, in the text that you just read, it used the word significant very often. And again, that I think may be a subjective, it doesn't significantly alter traffic patterns. That's a subjective term about what is significant, what isn't significant. So there is, I think, some gray wiggle room there.
Again, I was reading language quickly that Jay has pulled up on the screen. I was paraphrasing. Go ahead.
So I won't go over the minor changes, but in the subdivision regulations, it also outlines what qualifies as major changes. Those are changes which would result in new construction on the institution's campus, changes in land holdings by the institution, changes which would be contrary to any applicable provision of the zoning ordinance or which require a variance or special use permit from the Zoning Board of Review, or changes which may have significant negative impacts on abutting property or property in the vicinity of the institution. Now, in the case of the administrative officer making a determination, they have to make a determination in writing, and which would then go in the file. So in our world, in that justification would be assessment of those, whether it qualifies as a minor, whether it qualifies as a major, and why. Actually, it wouldn't be qualifying as a major. It simply would be a referral back to the planning board for a hearing if it was a major.
Thank you. The last one that you read was significant changes to the neighborhood. And we have a bunch of neighbors here. Who determines?
But that's done in concert with other criteria. Doesn't expand parking, doesn't expand traffic. These are things that maybe there was an issue of trespass, and the hospital wanted to put up a split rail fence. Do they need to go through a 4-month process because their institutional plan didn't contemplate a split rail fence? Or can the administrative officer say they have an issue with trespass? Their proposed solution is to do a very aesthetically, architecturally compliant and consistent design of a fence, not a solid 6-foot tall chain link fence with wire on the top, but something that just casually makes the trespass less. Again, to your point, Susan, there has to, I told you, do your best to eliminate shades of gray and get them in black and white categories. I made the statement, you're not always going to be able to do that.
Thank you. But you also had just said a tasteful and lovely fence, but a different administrative officer might enjoy that chain link with the plastic.
If you get if you are as selective in the selection of your planning director as you have been historically, I do not think you would get that individual who would come to that conclusion. Or if they did, yeah.
Right.
Yeah.
Yeah, and of those things, I think it's a good start to look at what constitutes a major and a minor change. The one thing that I always have difficulty, not just relating to the hospital, is no negative environmental impacts. To me, that covers such a broad range, and it's I think, very difficult to determine that. And I think that can be subjective because there aren't enough specifics to that. I mean, that's something I know we live with in our regulations and our criteria for approval, but
And again,
we have with conditions of approval, added on to that, or with required conditions, but
council made the simple suggestion to do something like what was contained in the subdivision regulations or reference the subdivision regulations. It gives the ability of staff to work with the applicant to, again, these are townwide standards that may need to be looked at closely, and if the board and the applicant go down this path, that need to be tailored specifically to the governmental and institutional use as it relates to healthcare institutions. So again, some of them, you may end up with A, B, C, D, and E, may end up with A, B, and C, with instead of one sentence in each one of those subcategories, but 2 or 3 sentences.
so I think it might be interesting then to see what staff can come up with that would be appropriately tailored.
Not looking to be over-regulatory, looking for clarity for the applicant so they understand which process they will be in.
Can I just say, we may not ever have a planning director who likes chain link fence, but it still leaves the possibility open.
Yes.
I think things that are directly, that are going to be most visible to neighbors or have an impact on neighbors are things that need to be considered. And I don't want to get into having a, 2 or 3 month public hearing about a fence, but at the same time, I would hate to see somebody say, sure, that's fine, go ahead and put that up. I don't know how, I'm just saying, as you're thinking about this, I think the appearance in the neighborhood is important, so.
Again, a lot of the comments I'm saying is with the understanding that in the next few years, as the planning board contemplates design guidelines, that there will be additional guidance available to both staff and the planning board. And Paul, to your point, there may be a section of the hospital behind some of their maintenance facilities where chain link fence up against the woods, black, 4 feet, is perfectly appropriate versus a chain link fence abutting a street in a neighborhood surrounded by houses. So again, to my point, not looking to be over-regulatory, looking for clarity so the hospital can clearly understand what the permitting process is and have that discussion with whoever sits in the department.
So certainly, I think if you can come up with some language and we can have a look at it and see if it gives us a greater degree of clarity and comfort. Okay.
The other aspect, and I'm sure council is aware of this, that when you move it to development plan review, you have a little less defined time period for review. So there's no, you must review and act in 65 days, you must review and act in X number of days. I know it's always the intent of staff as well as the planning board to review and get applicants through the process in the most expeditious manner. And again, since the applicant wrote this language, I'm sure they're comfortable with being in that DPR review framework.
It seems to me that if we have a greater degree of clarity, we should be able to continue with the normal major land development project format rather than going to a DPR. I think we live with timelines and time frames, and sadly some of which have been shortened for certain types of projects, but if there
I mean, Madam Chair, Jay Parker and I have talked a little bit about this. We're not necessarily adverse to the DPR review process. It may simplify things other than the time frame, and we can work with our legal counsel to see if within the adoption process of their plan, whether you can also build in some time frames. So even though they're not called out in law, council can give us guidance of whether we can build them into the regulatory structure.
And
Because this is a unique
Yes.
regulation.
So going to a DPR format, would that change our ability to allow for waivers?
That's the question that came to my mind when Jamie was discussing it. I would say unless what the project that they're proposing qualifies as a project.
Right, right.
So I think, again, if they're coming in for something that rises to the threshold of land development project, yes, that.
We do have a process in place, though, for waivers associated with development plan review currently. So
Waivers of DPR requirements or of standalone zoning ordinance requirements?
the waivers of the subdivision regulations, the requirements of the subregs.
Of the subdivision regulations, not, because I maybe I misunderstood it. I thought Jamie was discussing the possibility of the planning board granting limited dimensional waivers, which is allowed if it's authorized by the zoning ordinance. But yes, waivers of subdivision regulations are authorized in DPR.
Obviously, we would want to have the ability to allow for waivers where appropriate. Any other thoughts on this? All right, let's move on.
Moving on to Section D, again, that change from master plan to long-range plan. The primary change in this section is adds language to require campus property only, on-site versus off-site. The only thing I would caution is if there was a reference within the master plan or institutional plan that required them to have a conversation about off-site satellite facility, or in most instances potentially satellite parking. I don't see the harm in including on-site and off-site. If there's no off-site, the plan just references the fact there's no assets off-site that are contemplated as part of this plan. If there is an asset off-site, it becomes part of the plan. So, and again, Mr. Revens may have a solid reason why they were proposing not to do this. This is not intended to be a requirement that they list all of their off-site holdings. Only holdings off-site that would be linked to the campus as it relates to the functionality of that campus. A primary example would be a satellite parking facility or a shuttle system.
Could you just repeat that definition? So only holdings.
So the existing language was a list of all existing buildings owned or leased by the hospital. They've added the language within the hospital campus. You could change that language associated with the main campus as it relates to its operation. It's just, and again, I know the hospital is very conscious of revealing certain aspects of what would be denoted as a business plan versus a capital master plan. So trying to be cognizant of that. I'm sure there's a way to use the language to tie in revealing an off-site asset only if it's necessary to function, to make the campus function.
Any thoughts on this one?
Sorry, I have a question to clarify. If the applicant purchased another property in town and, say, moved their entire maternity operation to that other campus, wouldn't that just by default be affiliated with this campus because you are moving? So
Susan, there.
wouldn't
yeah.
everything be affiliated because now there's less cars here, but there's more cars there, and shuttles or whatever else they have? Like, wouldn't pretty much any satellite building be somehow affiliated with this main campus, just by the nature that it's the same
Again, I'm sure Mr. Evans can answer it better than me, but I'll do my best to answer your question. If they moved an asset from the campus to an off-site facility, either in town or in a surrounding town, I don't think it's germane to the master plan, institutional plan process, unless it has an adverse effect on the traffic or circulation associated with the main campus. So if they moved a maternity aspect off property, received all their appropriate permits within South Kingstown or an abutting municipality, and they left the space in the hospital vacant, I don't need to know about that other facility. I only need to know if the change associated with that movement has an impact on the main campus, negative impact, right? And that would be we moved maternity and we're replacing it with something that, instead of appointments every hour, now have appointments every 15 minutes, so I quadrupled my throughput. That I would want to know about, but I don't need to know the inner workings of their business plan, that they moved a part of the hospital operational aspects off campus if they have no implications on the campus in a negative manner. That's their business plan. That's operational, and I think that's something they don't need town approval to do. So if they have...
I understand, but if they did move something off campus and now they therefore needed 100 less parking spaces on campus,
They need 100 less parking spaces that day. They may need the 100 the next day. We don't know that. If someone moves something off campus, prime example, if you have a large commercial facility that is 200,000 square feet and has 4 tenants, and one of the tenants moves, you don't go to the developer and ask him to rip up a quarter of the parking lot because he doesn't have a tenant today, because he may have a tenant tomorrow. So the footprint of the buildings, the footprint of the parking lot are allowed to remain, but they're not allowed to expand. They're not allowed to intensify without a permitting process. But again, to your point, is if they needed 800 parking spaces today, moved an aspect of their operation off campus, that in 2021 only required them from a functional standpoint to have 700 spaces, so you feel they have an excess of 100. There's no zoning provision to require them to come in and abandon 100 spaces, remove it, and put lumen seed in. Again, the nature of that hospital is that space will, in all likelihood, be put to use.
I wasn't implying that they would need to abandon parking spaces. But then when they come back in 2 years and say that they are moving something else into campus,
They have to do the full analysis to see whether what they have, those 800 spaces, are adequate to bring in the new
Okay.
use.
thanks.
Again, it could be more or less intense than what was there. And that's why I think it's important in the regulatory aspect that the applicant has the ability to do a parking and traffic analysis and not just a hard count based on square footage, which is what is in the regulation today.
And Jamie, to your point, that would more accurately enable the board to understand whether or not there would be adverse impacts or not.
Yes. And again, I give examples, and sometimes to my detriment. But a good relationship to this is a parking code that requires X number of spaces in a retail setting, a 10,000 square foot business that is a grocery store. And it's a busy grocery store, so you need a lot of parking. The grocery store closes and a mattress store goes in. Do you still need all those parking spaces for the mattress store? But the code requires you. So if someone built a brand new building and it was for a mattress store, it's going to require a lot of parking spaces, but there's probably only 6 people a day who go to that mattress store. So again, the ability to have some flexibility to allow this institution to be able to operate, I think is critical.
Anything else on this?
Item number 4, this regards the circulation plan. The proposed amendment eliminates discussion of internal aspects of the site, parking, campus circulation, which is typically critical to any institutional master plan. Removes the requirements of submitting a traffic circulation plan. It removes a number of things. Again, I think these things are important to the planning process. And my statements stand. I don't know if any of the planning board members have any questions. And again, the other aspect is removing the terminology parking garage. There's no regulatory requirement to make anyone build a parking garage versus a surface parking garage. If there's terminology associated with a parking structure, any master plan or institutional plan can simply make the statement that no parking structures are contemplated at this time. You've addressed the requirement of parking structures.
I agree with that. As he said, we don't know what's going to happen in 10, 20 years, and it's not a requirement.
Yeah.
That language in this.
And again, I think it's clear, and I hope the planning board understands it, that in reviewing any plan, I don't think you have the discretion to say, I think you should build a parking structure versus more surface parking. That is an institutional decision, not a regulatory one. If if they needed a waiver for something or a variance for something, and their hardship was they don't want to build structure, they need the waiver or the variance to build more surface parking, then you have some regulatory say. But I'm not aware of a provision that's contained within your regulation that could mandate the hospital to build a structure versus surface parking. So I don't know if that was their concern.
Could I ask then, what's the benefit to removing parking garage from that statement? Where's the harm in leaving it?
They proposed to remove it. We're recommended it stay in.
Well, I mean, to me, when I read it, it means that they could put in a parking garage because it's not listed as a capital improvement anymore.
What the language that exists today says when they do a master plan, they have to make a statement regarding a capital plan associated with a parking garage or structure. They're proposing to remove that requirement. My suggestion is if it stays, they only have to make the simple statement that they're not contemplating any structure parking in the terms of this plan for the next 5 years. Or they could say 10 years or 20 years or ever because of the financial repercussions of a structured parking lot, which can take the cost of $5,000 for surface and bring it upwards of $20,000.
So I see no need to remove it.
And again, the hospital may have other reasons for why they thought it benefited them to remove the language.
All right, let's continue on.
I'm down to item number 10. Right now, within the regulations, there's a statement that says all parking on the hospital campus. And there's, in essence, an evaluation criteria as it relates to zoning compliance. They're proposing to eliminate the evaluation assessment of what parking is required by the zoning code. Again, our comment was we're not clear why this language was being removed, and we have actually been aware of the fact that the hospital is not compliant with the hard standard contained within the zoning regulations in 2020 and 2021. So again, at some point in time, due to the addition of employees or program, based on the number of programs, they would have been required to add parking spaces. That was not done. That was revealed in their master plan submission to the planning board. But again, I'll go back to the fact that any regulatory revision, in my view, has to address the requirements of the hard standard contained within the zoning regulations to allow them to do an analysis of the need.
So it would be up to the, and should be up to the hospital to say, this is what the regulatory requirements are. However, this is either a modification of our plan or a change, and we feel that because of our analysis, this is appropriate. Again, it's up to them. It's that whole burden of proof.
So again, in the analysis, if we'll just use round numbers, if the regulatory code required them to do 1,000 spaces and their program, they're implemented through an analysis could suffice with 800 spaces, they should be able to have a discussion with you to say why they shouldn't have to provide an additional 200 spaces. And it shouldn't be a report that says we're at 99% capacity and there's 4 spaces left. If you drive around for 15 minutes, you can find one. There's a happy medium between actual capacity and realized capacity. But again, that's up to the VHBs of the world to go through that program and that programmatic analysis. Sorry.
And that's pretty much the norm for.
Yeah. I mean, I wish in some aspects we could do that with some of the big box retailers whose pro formers say they shall have 500 spaces when they only need 2, and they want to pay. They're willing to pay for and will construct more than they need.
Just as an aside, there is a website that looks at Black Friday parking. If you Google Black Friday parking, and they'll show you all the empty parking lots on Black Friday. So I love the idea of flexible parking.
All right, next item.
Just give me a moment, Madam Chair. I'm making sure I don't miss anything. Item number 12 was just a regulatory reference. We found no issues with that. Item E, which is all new language, which is modifications to the approved institutional long-range plan. And, without going through all of these individually, the concern we have with these is it's devoid of any correlation to impact and utilization of the campus. It's just related to square footage requirements. So, the same aspect advocating for flexibility in the parking, because sometimes a hard standard doesn't tell the story. This works in the same nature for this section. Just because they construct something new that is less than 3,000 square feet doesn't mean that the implications on campus circulation or traffic in the neighborhood isn't significant. It's just a number. It doesn't correlate to the utilization of that space. If it's an internal corridor that's only moving people from point A to point B, it doesn't affect. But I'll equate it to a restaurant. If a restaurant was and this is an extreme reference, if a restaurant was just a sit-down restaurant with 50 seats, and they proposed a drive-through, there's no additional square footage, there's no expansion to the restaurant, there's only an exterior change of a menu board and a drive-up window. But that has significant implications with regards to circulation and traffic at the street. That's an extreme reference, but again, I think here what we're trying to portray is that these aspects need to have some trigger mechanisms. So the construction of new structures of 3,000 square feet or less adjacent to or supportive existing use on campus, so long as it doesn't increase, could be, to Mr. Jordan just said, noise. It doesn't increase whether it's peak flow traffic, average daily traffic by more than X percent, or the percent could be 0, 1, 2. Again, I'll prefer to the transportation individuals to work on something there. The same thing. Parking facilities of 10 or few spaces. If it's only 10 spaces and someone goes and parks in those spaces for 8 hours on a 3-shift rotation, I don't think there's any implications. But if it's 10 spaces and they turn over every 10 minutes, there's a different impact. I just think you're lacking that correlation.
So would you suggest having a set of more specifics so that this could be better understood?
I think there needs to be some clarity to the provisions associated with impact, not just a hard square footage. And again, I'll go back to the parking scenario. Just because a regulatory aspect says you need X number of spaces doesn't mean that the use is going to utilize the spaces the regulation wants. The reverse is here. Because you're adding 3,000 square feet doesn't mean you don't have impacts to the site or the neighborhood. You may be able to make the conclusion that you don't have impacts, but there's no requirement that they even entertain that type of analysis. It's just under 3,000, you're good to go.
So having that type of analysis, which at least makes an estimate of what the impact might be,
right,
be important.
And again, I have no issues with if you can eliminate that as much of the gray as you can, get it into a black and white criteria, that it's still a right that the hospital holds, but it holds them if certain triggers aren't placed. That 3,000 square foot addition is okay if it doesn't affect peak flow traffic, or it only increases peak flow traffic by 5%. The other aspect that we were concerned about is how many 10,000 square foot additions can you do? Can you just keep adding 10,000 square feet at a time? 10 spaces, so you had 100,000 square feet and 100 spaces, but you do it incrementally, so it's just allowed by right. So again, tying those into impact I think I don't have an issue with if they did 10 additions at 10,000 square feet with 10 parking spaces every single time, so long as the net effect of those doesn't have lasting effects on either the, if you're affecting the campus, you're potentially affecting the neighborhood. If you're affecting the neighborhood, you're affecting the town. So, and again, trying to provide the flexibility for the hospital to be fluid and react to a changing environment.
Any thoughts on those points? Robin?
I think that allowing small incremental changes like that is a poor method for planning, that an institution should have an overriding plan and 10 spots here and building here. And that just doesn't seem like a plan. And it's only going to lead to us having to hear arguments about things that are impracticable. And then we're going to be pushing our boundaries closer to our neighbors and trying to make things work because it was done piecemeal.
I don't disagree with you, Robin, but I think the provisions can be made that so long as they're building within the confines of their campus with some parameters associated with that you can get some certainty of an outcome. And again, their long-range plan should contemplate some of these changes. So again, I think the planning board would have substantial pushback if you adopted a long-range plan and over a 5-year period, the zoning building department issued 5 permits for 10,000 square foot additions that weren't contemplated in the long-range plan, because that in essence would make that plan useless. You have to have some trust and some faith in the institution that they're doing their the hospital has to do a capital plan. And
Or
money,
legally, we won't be able to complain that they're
money
allowed
does,
to have another building.
and general counsel's here, but he can probably nod or confirm. Money just doesn't fall out of the trees onto the laps of the hospital administration to undertake large projects. That they have to fundraise, they have to have a capital plan, they have to, dot their I's, cross their T's, save their money to contemplate additions. Most of those additions should be in the long-range plan or contemplated. There are sometimes things you can't predict. And again, suppose, they send all their laundry off-site and someone had the brilliant idea, because it made financial sense, to bring their laundry facilities on-site and employ 4 people in an 8,000 square foot building. You're actually going to eliminate a delivery truck because no one brings laundry to the facility anymore. It's all done internally. So you forego the truck trip. You have 4 employees in an 8,000 square foot building, but maybe they didn't contemplate that 2 years ago. Again, I think it's potentially the sky is falling analysis that the hospital would ever contemplate, 10,000 square foot additions over a 10-year period. I think at some point in time after the 3rd one, the planning board would put a stop to it through a regulatory change. But I don't foresee that, nor in my 30-plus years as a planner have seen an institution go to that length to circumvent a regulation. And I've seen some creative things in my career. I haven't seen that much creativity. And again, general counsel's here representing the hospital, and he may be able to speak to that. Again, Madam Chair, I don't know if Amy Goins has anything to add.
I'm here for any questions.
I want to just come back to I agree with you. I can't imagine anybody coming in and putting in 10,000, 10,000, 10,000. My concern about adding a 10,000 square foot parking area is, again, where is it on campus in relation to butters, and what does it look like to the abutter? I mean, are there going to be landscaping requirements? If there's no involvement from the planning board, is the planning staff working through those issues and saying, okay, you can put this in here, the setback is 20 feet off the neighbor's fence, and now they're looking at lights shining in. I'm just wondering how it would...
Paul, to your point, I think it's germane to the process that their institutional plan contemplate additions to parking. And in that contemplation of additions of parking, they develop the design standards and the manner for which they would be done, so that if they are in close proximity to a property line, that the following provisions will be implemented. Landscape buffer, opaque fence, orientating the parking so the headlights don't shine into the homes. That's what I would look to guidance in their institutional plan to allow them the flexibility to put 10 spaces in. I don't think the institutional plan should just make a broad statement that says the hospital has needs or anticipates needs over the next 5 years to install 10 parking spaces and just leave it at that, because then you're suspect to implications to what the impacts are where those 10 spaces go. So again, these things allow them not to have to revisit their institutional plan. They do not give them carte blanche with any existing standard. So even though, it says they may be able to put 10 spaces in, they still have to adhere to the design standards in place within the town's regulational framework when those spaces go in. It just doesn't require an amendment to the institutional plan. So,
And when will we know when those spaces go in? And
excuse me, Robin, can you repeat?
will we know when those spaces are going in? Like, is it visible to us that, oh yes, it did happen the way it should?
Again, you can build into the process that upon application to the zoning officer, that they make the planning board or administrative officer aware of that. In most instances, due to our permitting process, when something goes to the zoning officer, there is a check and balance within our department and view permit. But the hospital itself, under the regulations, our first read at them is not, if they came in for the 10 spaces, they're applying to the zoning officer for the 10 spaces. They're not sending notice to the planning department that they're doing that. That's an internal aspect. If the board's concerned about that, you could put a provision in here that requires any application under the exemptions listed in section X require notification to the administrative officer. It just puts us on notice that they've, 2 doors down from us have submitted an application. Doesn't give us any regulatory authority, just gives us awareness. Doesn't give the town any more regulatory authority than it would ordinarily have. Just puts us on notice in the department.
I'm honestly concerned with it being regulated, and I just don't know. Does that fall upon one letter that shows up in an office and one person's supposed to do a drive-by or something? Like, it just seems kind of unregulated.
Again, there are, I'll let Jay handle, but he's going to go over right now in your regulations. There are exemptions afforded to the hospital under the master plan permitting process that don't require changes to their master plan and don't require any additional permitting through the planning board. They can go straight to zoning. I'll have Jay expand upon that.
Yeah, I think there's a little bit of a disconnect with the way that the text has been presented, because the section that I read to you previously about minor changes actually talks about one of the standards is does not result in an increase in building floor area of more than 500 square feet. So obviously that 10,000 square foot allowance wouldn't necessarily apply. But in inherently applying the language in the subdivision regulations, those determinations are made by the administrative officer. So the administrative officer would give the okay for them to go to zoning and tell zoning, okay, it falls in the exemption category, or it's otherwise allowed. But I think it's a little, when you look at the subdivision, the section of the subdivision regulations that speaks to changes to institutional master plans, that also would need to be revised based on what is being presented this evening, because our existing language is not, they're not consistent with each other. So if we were to go off of our existing language in the subdivision regulations, the administrative officer has that review provision for those types of changes. I think what Jamie's speaking to is affording the administrative officer additional standards to apply is what really is required to make sure that all of the town's concerns would be addressed. So I think there is a considerable amount of work that would need to be done to ensure that there's consistency between the language in the subregs as well in the zoning ordinance.
And certainly those kind of standards would really help with the clarity and give the planning board the assurance that the administrative officer would be able to make an appropriate decision because those standards were in place. So definitely some changes to the language, some additions would be very helpful for everyone. So we are at the end of our charts. Would the applicant like to speak before we hear from the public? Or would you like to just absorb what you've heard this evening?
Madam Chair, I'm not sure what you want us to do. As you went through all of these and listened to the presentation from Mr. Rabbit, and then most of you, either verbally or by nodding, expressed your views of what he said and what he's recommending. So it's not at all clear to me what you expect from us at this point. And I think the tone of the comments that he made as he spoke to you this evening and the balanced approach that he expressed, I thought was reasonable and appropriate. I think that the way I read some of these comments and the tone that was in the written words, I'm not sure they reconcile, and there's a lot of things that are, I think, confusing to some of you, and I'm sure to some people in the public, because as I think you know, we're subject to all of the same requirements for building anything on this property as every other property owner in town is. So we can't install a parking space or an addition to a building that doesn't meet the requirements of building, planning, and zoning, and if it doesn't, we have to go and ask for approval from one or all of those places. So the idea that there's anything we're trying to do that would make this the Wild West and we can just treat this like a Monopoly game and keep adding hotels to Boardwalk at 10,000 square feet apiece, it doesn't pass the laugh test, number one. And number two, as you know, because you're all reasonably familiar with the campus, there's no room on the campus to do that anyway. So the campus, as we've said from the beginning, is built out. There's some tweaks that we're trying to make it more relevant to what my client needs to do to serve the community. We're trying to do that in an expeditious way, and notwithstanding the idea that these things, once it's approved, go through in 3 or 4 months, we all know that that doesn't happen. All of us who work in this on a daily basis, not just for this, but for anything else. In today's world of building things on properties, these things go on for months and months and months and months and months, and you've had several of those before you in recent months, and I don't need to remind you of what they were, because you had to sit here and listen to it and grapple with it and deal with it. So we're concerned about time, and my thought would be that it probably makes sense for my clients and I and Mr. Rabbit and Ms. Goins to sit down and work out this language and try to come to you with something before the next meeting so you can act on it in January that you'd be comfortable approving. But we want to be very clear here that the parking garage, if you read the language in the paragraph, it says in the prior clause that we have to list any proposed new structures. We don't call out any other structure. There's no reason to call out parking garage, A, any more than we call out medical office building or operating room facility or laundry facility. So why would you have a list of all that? It says new structures, covers everything. Number two, we wanted to kind of let you know, and everybody else in the community know, that there's no plan for parking garage. And the cost of that is even more than Mr. Rabbit indicated per space. Number two, way more to build them. Number two, as you know, most of them are not overly attractive, so we'd have all kinds of problems trying to screen it out and buffer it. Number three, elevate it so you get all the lights from the cars up higher and therefore being more intrusive. Number four, you lose 15% of the ground level spaces for the structure to hold the deck above it. And with all of the needs that community hospitals have, the last way they try to enhance parking would be with the garage, because there's more friendly, more user-friendly, and more or less expensive ways to do that. So that's the reason we took it out, because we don't want people to be misled that lurking out there, we're going to come back someday with a parking garage. Now, as I say that, I'm not smart enough to know any more than any of us are what the world will look like in 25 years, but there's been no serious thought to a parking garage on that campus for a long, long time, and there's none now. As far as the parking goes, the tweaks that they're making to the campus, like which we talked about before, like the west entrance, will become the main employee entrance. And when that happens, the parking that's associated with that side of the building that's underutilized now, because you can't see how you can get in the building if you park over there, will become more attractive. And the employees will have a parking plan where employees will be assigned to certain areas where they can park, not to particular spaces, but to areas, so that the spaces that would, people who are coming in and out, whether they be outpatients or visitors or family who are transporting or accompanying people, would have spaces that would be available that would be closer to the regular entrance to the campus. So that's all part of things they're trying to do here. And you should know that that's pretty advanced in terms of what they've done. It's separate from the from the ordinance, but it's going to make a big difference in how things work. But even now, and for the last years, The parking meets the needs of the institution. They're not going to put facilities in there and not have people be able to get in and out of the building and not have places to park because it defeats the whole purpose. But they've already moved things around in different places. Things have left that campus and other things come in. And that's not part of this process, and we don't want it to be any more than when any other buildings in town change tenants or change occupancy, whether it's from the grocery store to the mattress store, whether it's from the medical office to the law office. We are not now, and don't want to be, in this wheelhouse for those kinds of changes, which are ongoing now. And there's no plan now for some satellite parking with a shuttle service or anything else. But if there was, your ordinance, for some reason, unlike most municipal ordinances, doesn't prohibit off-site satellite parking in all of your zoning districts. A lot of communities do. But, so you can't have as a principal use in a business district in many, many communities in Rhode Island, other than downtown Providence, a parking lot. As you can here. And you had an example of that some time ago in a case that your chair is familiar with. So, but there's no plan to do any of that. The plans are all for modest tweaks and improvements that will not only help the hospital operate more efficiently and serve the community better, but it's also to make the neighborhood better. There's a whole new lighting plan that will go in for the outside that will no longer have the lovely lady who came here a few weeks ago and complained about the light shining at her bedroom window. Well, that'll all get fixed if we can get through this process and get these things going so that the exterior lighting will meet 2021 standards and not 1970 standards. But, so I think, Madam Chair, if the planner has the time, and Amy has the time, if we sat down, we could work some of these things out, because we're not going to get it done here, I don't think, effectively at all, and I think you appreciate that. And all of us have had a lot of experience as to how to write these things, and none of us are rookies at it. So if we had a couple of half-day sessions in the next 2 or 3 weeks, so we get this done before the middle, the holiday, then we could hopefully get this back on your docket for a recommendation on January 11th, and I think that's what makes the most sense. But we need to be comfortable that everything that's there is protected and allowed, and we can't come back in here and have somebody say, well, no, we're not going to approve this. What's already there, our position is it's approved, it's legal, it's conforming, and it's going to stay. And we don't have a huge amount of building changes on this campus, and the thing that's in the background of some people's minds, I know, is parking, and what if we get any additional land that's contiguous to the campus. I don't think it's a secret that we'd be coming in at some point, if we could have the legal right to do it, with some kind of extra parking on that premises if we get it. But that's all this really is. There's not any secrets, or there's not any hidden things, or there's no other stuff out there that we know about that we haven't shared with the staff, and there's nothing we're trying to not keep you informed about. But we get a little concerned when we talk about off-campus things, because this whole healthcare industry has changed, and the big hospitals now own a lot of the healthcare practices. You may or may not be aware of that, but a lot of the medical offices that used to be owned by the medical professionals are now owned by hospitals. And this community hospital may have to do some of the same things, and some of those facilities could be in South Kingstown, they could be in Narragansett, they could be in Charleston, they could be in North Kingston, they could be anywhere. And they don't directly impact this campus, so we're trying to make it clear that whatever goes on in those places, even if it might send a patient who goes for OBGYN to an office in North Kingstown and then comes to the hospital to have their baby, we don't want to be in here talking about that as part of our master plan.
Susan
And-
made
and
you
we-
nervous, didn't she, with her analogy?
And we don't think that you would disagree with that. But some of this is coming across in the way some of these things are written. It's not really clear. And you know, Jamie's talking about standards, and we all want standards. But planning and zoning, once you get beyond the absolute standards of height, of setback, of this or that, is nothing but gray. And it's been that way since before any of us had gray hair. And it'll be that way for a long time until the next iteration of whatever the next reform might be. So I think our emphasis is to try to clean up whatever disagreements we may have, get some language before you, and move on at the January 11th meeting to a recommendation to the council, if that meets with your approval, Madam Chair.
I think that's an excellent idea. I think the having you folks meet with staff and work on the language is very important. Clarity is important, and comfort for everyone is important.
And we want you to be comfortable, but the 10 spaces was only meant to be like, it's like making a one-car driveway a two-car driveway. And you know that it's de minimis how much 10 spaces would impact this place. And one 10,000 square foot addition is de minimis, but if it had setback relief or height relief or parking relief, it would still have to go to the zoning board. And as you know, Madam Chair, and some of the newer members may or may not, everything you do is subject to appeal to the zoning board anyway. So we're not getting around anybody's concerns legitimately about a fence or shrubbery or parking or building. We're just trying to not have so many layers to it, because there's so many now that we've been spending an awful lot of time on this, and we were trying, maybe effectively and maybe not, to get an ordinance that would be a little easier to work with for everybody. But I think if we sat down together with all of us, I think we could work through this, you know, fairly readily and get to something that's reasonable. And just one thing about the parking. Mr. Abbott talked about all the manual stuff, and he gave all the examples, and they're all good examples. The mattress store and the grocery, and the grocery store are a good thing. A restaurant that takes reservations and a restaurant that doesn't is a good thing. The restaurants that don't take reservations, what's different? You got all these people waiting for seats, so there's more cars in the parking lot. The ones that take only reservations have less need for parking because they don't have 40 people waiting for tables. We don't have people waiting for tables. Everybody comes in there on an appointment except the ER. So we shouldn't be at loggerheads, and the concerns that the neighbors have, some of them can't be resolved, a lot of them can. And certainly all the long-time neighbors who've lived there forever, all they're going to see is improvements in these changes, I think, for the most part. And for the newer neighbors, you know, when you live near a busy hospital, you got to accept if you moved into it in the last 10 years any more than if you move near the airport or if you move near Route 95 or Post Road or whatever they call the highway on Route 1 through Matunic. You're going to expect some impacts from that road because you chose to buy alongside it in 2021 versus 1956. So with that said, I hope we can put this to bed, get some language worked out between us, and get on your docket for I think it's January 11th, am I right, Madam Chair?
Oh.
That's what Mike Ursillo, I think, told me.
Sounds correct.
I just want to be sure about that because we kind of got lost this past month from when we agreed to the extension, and
Yes.
we're just trying to see if we can keep this on a track to try to get some action on this at that meeting, please.
So
Madam
it looks
Chair.
as though the 11th is the work session and the 25th is the regular meeting.
But can't you do this at a work session to make a recommendation? It's only an advisory opinion.
We can. What we like to do, if we absolutely have to, is we make it a portion of that meeting because it becomes a regular session. So
On the
that
11th.
if we're going to vote on something,
Right.
it happens at a regular meeting. So if that can be accomplished by the 11th, great. If it needs to be the 25th, that's fine as well. Certainly, we would love to have an extension from you folks. Thank you for the reservation analogy with the restaurants. That's very interesting. And given the season, we all want to see some comfort and joy for everyone involved.
We do, but I just want to try to keep us on a, with all due respect, on a time schedule. So if hypothetically, why couldn't part of the meeting on the 11th be a public meeting for the purposes of making the recommendation instead of waiting 2 weeks? Just how you advertise it.
Amy, tell us what it looks like.
We are here tonight at a special meeting at the request of the applicant, which already caused a delay. Your next work session,
That's not accurate.
I thought you were unavailable.
you were unavailable for the work
When
session.
when we agreed, if we look at the record, and I don't remember the exact words, but I'll look it up and spin it back to you tomorrow if I have to. When we agreed to the last extension, it was because, quote, we were going to have a meeting in a particular week, and the chair or someone was going to poll the members and schedule that meeting. And that never happened. That's what happened. I mean, we're 89 days from when this was certified complete, and we're discussing something that we got yesterday. I don't know when you ladies and gentlemen got it.
Yesterday.
So it's kind of hard to be doing this on the fly, but
It is. Well, you know.
I'd like to try to do the 11th.
We
if
can
could,
aim for the
please.
11th, but if you give us the extension until the 25th, that, you know, I'm sure that both parties will work diligently to come to an agreement on the language, and it's only a difference of, what, 2 weeks?
Can you give me a minute to talk to my client about that, Madam Chair?
Sure.
Thank you
Madam
so much.
Chair,
And I want to give the public a chance to speak as well.
Certainly.
They have been-
Staff's conservative view on your meeting schedule is that you have a work session scheduled for the 11th. Your applicant's going to be, at your direction, working with staff to make revisions. I don't know when those revisions will be in their final form before you, but you may have additional questions. I think the work session, again, from a conservative view, the work session allows you to work with the applicant in this type of setting on the final format of the language, where you typically discuss, finalize, and then direct staff to prepare a motion for you for your consideration at your regularly scheduled meeting. I don't know if your intent is to have staff work with the applicant in the next month, although we have 2 holidays in that next month, and also anticipate drafting a motion on a regulation that you haven't reviewed as a board.
Agreed. I think we need to see the language, have a conversation, firm up the draft motion, and it's, you know, it's a matter of 2 weeks. So if we have a hard date of the 25th, try for the 11th, but again, because we want to do this correctly, this is something that will have a significant impact for the next 10, 20 years. We want to try to be flexible, but retain the regulatory authority that we should have, and it's going to take some fine-tuning, obviously.
Madam Chair, I talked to my client, so we're fine with Mr. Rabbit's suggested schedule of the work session on the 11th and the vote on the 25th.
Okay?
But we'd like to see if we can get a commitment that we're going to work on this together and try to get the language that we're going to work on together done before the 25th.
And I like the fact that you suggested 2 half-day sessions. That's
Well,
probably wise.
we might. I mean, with whatever.
Or whatever works.
But just to break it up a little bit, maybe a week or so apart, so we could try to focus on this. And I know the planning department has a lot of things to do, and I know the holiday season is busy, but we'd like to try to keep us all focused on this so we could
Of course.
move through it if that's okay with you, Madam Chair.
Yes, of course.
Thank you.
Thank you. Is there anyone from the audience who wishes to speak? Oh, do you have some comments?
Just very briefly, I
Just
know.
restate your name, please.
Hi, I'm Andrew Prescott. I'm General Counsel at South County Health. I want to thank everybody on the board and staff for working with us on this really important project. I'm new to South County. I started a little in early August, so after about 30 years of working in law firms, I decided I wanted to do something that would really be a way to give back to the community. So I joined South County Health. I live in Narragansett, so this is where I live, and it was an opportunity to really contribute to the community, and so I really appreciate you all hearing us out and working with us on this. I've come to know just a couple of things in my brief time at South County Health, really two primary things. One is that I've joined an institution that thinks of nothing really else but how to serve the community, how to deliver quality health care to the people who live in South Kingstown and all of South County. It's what gets us out of bed every day. It's all we focus on day after day is how can we be the absolute best hospital and provide the best possible care to the people who live around here. That's what we do. Secondly, Rhode Island is the single worst state almost in the nation in which to operate a hospital. It is incredibly difficult. It is incredibly financially challenging because of the abysmal reimbursement rates that are set at the state level by OHIC and the state regulators. Things are only going to get harder for us. As Jack alluded to, Lifespan and Care New England have almost, all of the market share in the state already, and they're talking about merging. And so we, an independent community hospital, are facing that daunting eventuality, hopefully not probability, but it's what we have to plan for, and we have to figure out a way to be competitive and to keep patients coming and provide the best possible care. And so having the ability to sort of turn on a dime and make changes that keep us competitive and allow us to have the best possible equipment, the best possible doctors, is so absolutely critical. And every dollar that we spend on experts and lawyers and going through, and I came from law firms, so I like spending money on lawyers, but, sorry, Jack. But every dollar, all the resources that we put to that means resources that we can't use to improve patient experience, buy new equipment to provide radiation therapy to people in South Kingstown with cancer. Like these are trade-offs. Resources have to be spent on one thing or the other. And yes, Mr. Rabbit, you're absolutely right. We have capital campaigns, but this business is turning on a dime. I mean, it is changing every month. And so we need to be able to eliminate service lines, add service lines, build out the facility in a way so that patients from Connecticut want to come to us so that we can stay in business and remain a viable entity. And so I'm just asking anything you can do to help make the process of operating our hospital less administratively cumbersome, less difficult from a regulatory perspective. We sincerely appreciate it. And the idea that Jack proposed and that you've agreed to sort of work together to sort of make the sausage in between meetings here, I think is a really good one, and we really appreciate it. So thanks for your time, and nice to meet you, and look forward to working with you.
Thank you, Mr. Prescott. We really appreciate your candor.
A quick comment.
Sure, Paul.
I think I understand absolutely the need for the hospital to have flexibility, the need that it serves in the community, and I think our responsibility is to make sure that you can do that and remain a good neighbor at the same time. And so that's again what I sort of keep thinking about here is always going to be the impact on the neighborhood, the traffic, the noise, the lights, and whether or not it's an administrative decision or a board decision, so long as somebody's looking at it and making a reasonable decision, and as Jay said, putting something down in writing. This is why we approved this or disapproved it. But yeah, absolutely. I think the flexibility is key, but also, hospitals, I think just in general aren't, they swallow neighborhoods whole in some places. So.
Yeah. Well, if you look at our website, it says that our mission is to be the most trusted health partner. And the word trust was used earlier tonight. And I think, although we do have a new Chief Executive Officer, Aaron Robinson, South County Health was a client of mine long before I came on as General Counsel. I know that it was a trustworthy organization when Lou Giancola was the CEO for decades. I know it's still a trustworthy organization. And so there has to be, although there should be standards, and Mr. Rabbit's right about eliminating the gray, there also needs to be trust. And I don't think we've done anything to, cause any doubt that we're trustworthy and that we're trying to do the right thing for the neighbors. So,
I'd like to actually say something. So I'm Susan. Hi.
Hi, Susan.
I think it's my understanding, though, that whatever changes we make would persist if, say, one day you did sell out to Lifespan or Yale New Haven or a large corporation. So I think that's part of our hesitation, just to make sure that we get this right, because you are an awesome neighbor. But if it's not you anymore, these persist.
Understood,
So, yeah.
and that's a fair point. We let me tell you, we will not be selling out to a for-profit healthcare agency, and we want to remain viable community hospital. You're right. I mean, just as we don't know who's going to be the planning director in 3 years, you don't know for sure that we'll remain completely independent. But I think we need to do something that works for everybody.
All right, is there anyone who wishes to speak?
Hello, how are you? Patrick Quinn, 30 Hillcrest Road. Just a couple of quick points. Just wanted to clarify, where are we at with the adjacent property, and what would happen with the development rights or prerogatives of the ball field property if this were to go through in some iteration like we've been talking about tonight? Because that's kind of a wild card here. I don't want to lose sight of the fact that if you change essentially the ground rules for the hospital and that property goes through the whole process that it's in right now, somehow being unparked or flipping park designation to some other property in West Kingston. So that really needs to be figured out. What are we applying this to? Because we keep talking about the campus being completely built out, but the ball field is not built out. It's a field. So that really needs to be addressed. Mr. Prescott is 100% correct. The hospital situation in the state is pretty volatile, but yesterday's coverage shows that the larger hospitals did quite well despite the pandemic. Most of it was public money. Most of it was CARES Act money, ARPA money. So both Lifespan and Care New England benefited from that. I don't know exactly what happened with South County Hospital. The distribution of money was based on COVID census. Initially, it was based on Medicare census. In most community hospitals, I don't know this hospital, Cold, the primary payer is Medicare, which is not state regulated, it's federally regulated. Insurance regulation is at the Health Insurance Commissioner, as Mr. Prescott indicated, but that's probably not the largest payer at South County Hospital, but that's important. One other point that I would like to make is that there's a number of different CON processes that require the hospital to get approval from the health department on a very, I would say it's pretty fair but aggressive time period. So looking at the time periods under the approval process of the CON for capital improvements and aligning them with the process of capital improvements that they need to run by you might actually expedite the whole thing. So if those two things could be aligned, the CON process at the Department of Health and the local regulatory process, that might save everyone quite a bit of time. So appreciate your time and energy on this, and have a wonderful holiday.
Thanks, you also. And as you know, we do not have the any kind of regulatory authority with regards to the ball field and any changes to that. I don't know if Amy and Jamie have any other thoughts. I mean, it's not within our purview.
No, Madam Chair, I think your comments stand on their own, that you are not the policy board associated with the composition of that land transaction. That lies with the town council.
Is there anyone else who wishes to speak?
Hello, I'm Elle Nordzy, 8 Broadmoor, Wakefield. This is not the first hospital I've lived next to. It's definitely the smallest. So I'm well aware of the impacts of living next to major hospitals in major cities. I really wanted to put this out there that last meeting there was a question about the hospital's knowledge of Ordinance 603.2 and needing the master plan requirement. I went back because I knew I had seen it, I had heard it, at the Town Council work session of January 13, 2020, pre-pandemic. There's about a 9-minute presentation from Kayla Gray at the time, the Director of Planning, and it was all about healthcare institution master plan. It went through the whole explanation. She had done a ton of research, so I understand that there's been a change in staff. So I just wanted to answer that question because maybe there were some internal discussions and it's been answered since, but not in a public forum, where the hospital was well aware of this requirement. In 1997 was the first iteration. 2001, they updated it. 2006, it was amended and extended for an interim amount of time that was undefined as they prepared for the new 5-year plan, but that was 2006. 2019, they had applied for a new institutional master plan finally, with the intention of updating it fall 2020. So obviously between 2019, fall of 2020, there's a pandemic, things can change, but that application was out there and the hospital was well aware of it. Immediately following that presentation, the hospital's CEO himself spoke and gave his own presentation. So, I mean, they were well aware of it. At that presentation, she said since 97, the town farm park has been part of the discussion for parking plan and balancing the needs of the hospital as well as the residential neighborhood. The whole reason why in 97 this master plan came about was because the hospital was actually non-conforming in a residential zone. That is why, in the first place, they said every single time they had to go change something because it was non-conforming, it was this cumbersome process. So every single time they had to come and say, hey, this is non-conforming, I need a variance, I need a special use permit, they said, let's put in this master plan, and that will save you the grief of coming back over and over and over again. So here we are more than 20 years down the road, and it's like the same story. It's like Groundhog Day. It's like, well, this is too cumbersome. Like, there's a reason why in 97 they went through all of these meetings. There's a reason why in 2020 and 2019 the former planner did all the research on the history of why the hospital needs a master plan. And I think we should continue down the path of oversight from planning board, from public hearings. So I'm in agreement that removing that is inappropriate. There's this provision in the proposed ordinance having public outreach meetings or hearings, but that doesn't need to be in an ordinance. The hospital can just make their public outreach hearings. I mean, they can come and walk down the street and say, hey, we're having a meeting, come and give us your ideas. The only time that myself and my neighbors have been invited to a meeting, it didn't go the way that the hospital wanted. He was upset that we didn't just acquiesce to, yeah, we think like paving over the park is a good idea. Like, we don't agree. And it just ended kind of upsetting for everybody involved. But I haven't seen that hand being extended, like, hey, we want to be a good neighbor, that to date has not been shown. There's not been that goodwill. We've been asking for parking studies this whole time. So again, it kind of feels like Groundhog Day. It feels like we're all like spinning in circles, because we've been saying to the hospital, please show us why you would need this 7+ acre parcel, which again, I know that's not in your purview. That was Recreation Commission, Town Council. we were asking for those parking studies, so maybe that is the answer, instead of having by building square footage, you need X amount of spaces, show us the parking studies, but that's what we were asking for all along. It's a little silly to me that we're talking about wasting money or, spending money on lawyers and application filing fees and the process when we're just like ping-ponging back and forth, it seems like. And that's just what we've seen over the years. And again, understanding that this is a different administration, different employees, different board members. I would, again, really caution about the language in here that says, any land that might be acquired. I echo what my neighbor says about the hospital is built out, but then what if you add another 7 acres? There needs to be an oversight on that. Like I said last time, there's going to be stormwater, earthwork, lots of action associated with converting the use from a public passive use to a private parking lot. I also, I got to caution you, South Kingstown, Rhode Island is an extremely different place from Chico, California. Out in Chico, California, on the other side of the country, is a place called Enloe Medical Center. It's a nonprofit, independent hospital. And they have had the issue of the hospital promising there will be a public park, we're going to work with the neighborhood, but there was no actual regulatory framework for making sure that those promises were kept. So, Chico and the neighborhood has been having a problem since at least 2016. Certainly prior to that, that's just, the first articles that I found about it, that there was this promise of, hey, we'll work with the neighbors and we'll just have these meetings, as described in this proposed ordinance. And the promises weren't kept because there was no oversight from the actual, the governmental bodies, the ordinance, any of that stuff. So I really appreciate your attention and your time. I hope that we don't end up like Chico, that we don't end up like Enloe, because they don't trust their neighbor anymore. And I do think that we do need to take our time on this. Again, I said that before, but there are so many little things, like we're debating the words, if this is required or, whatever it may be. It's important because the next thing you know, somebody is kind of doing something that was unintentional, and it's the unintended consequences that we really need to watch out for, because this is, at the end of the day, a residential neighborhood. It once was non-conforming, and there's a lot of different things that are allowed in a GI zone if we relinquish that oversight. So I appreciate your time again. Thank you.
Thank you.
Madam Chair, can we have the speaker repeat their name? I'm not sure our recording picked it up.
L. Nordzi.
Yes, L. Nordzi. Thank you.
Thank you.
Hi, good evening. I'm Elizabeth Scott. I live at 30 Hillcrest Road. I think the many concepts that were discussed this evening, in many respects, seem reasonable. I do think the idea of whether you call it a master plan or a long-term institutional plan, whatever the new terminology was, the idea is that you're setting forth a vision for the facility that identifies, what they foresee happening in the next 5-year period, and the idea that there is some implementation schedule so that everyone has some idea of what the thought is for when this is going to happen, just gives assurance to everybody, the town and the neighbors, about an idea of, what the entity, who, they're a big neighbor. And so I think we all just need to kind of have some idea about what they're planning. So I would just very much encourage that there be some requirement that it be redone every 5 years, and from significant amendment, whatever, that all seems reasonable. But that there be some implementation schedule included, which obviously isn't binding, but it just gives us an idea. And then the only other thing I wanted to comment on is the idea that there would be certain things that would be considered within the approved long-range plan. And to me, expansion of up to 25% of the square footage is not a minimum expansion. And, as has been stated multiple times, the hospital property is pretty much built out. So kind of anything that they do anywhere, kind of like, you make a move here and someone feels it. It's like, 10 people sleeping together in a bed and someone, rolls over, everyone feels it. And so I kind of feel like that's where we're at, that they've kind of expanded to their edges. So even a 3,000 square foot building, depending upon where it's located, could be, it could be kind of a significant thing for the neighbors. So I would just ask that there be really consideration that those changes be de minimis. I mean, obviously anything that happens inside of the building, as has been stated, certainly me as a neighbor, I don't really care, as long as it doesn't have adverse effects upon the neighborhood. So I just ask that there be some consideration to that. And very much appreciate the support that there be public notice on the public, that the public be formally notified of the institutional plans. That's really important.
Thank you.
Thank you, and happy holidays.
Is there anyone else who wishes to speak? Any further comments from board members? We would probably like to have a motion to continue this matter to our January 11th work session. Is that what we're doing, Amy?
Yeah, with direction to staff and legal counsel to work with the applicant on revisions.
We have a motion from Pete. Do we have a second? Second from Paul. Any further discussion? All those in favor say aye. Aye. Motion carries. Thank you, everyone.
Motion to adjourn?
We have a motion to adjourn from Paul. Susan has something.
Oh, do we have another item?
Oh, second. Yes. Yes. I didn't print it out, but I know I saw it on the line. So everyone has the schedule for... Do we need to discuss it, or? Okay.
It's something that we're required to submit to the Secretary of State every year for every board and commission, anticipated schedule of meetings, tentative schedule of meetings.
Someone like to make that motion to continue that?
It's a requirement that it has to be filed. It is not binding.
Right. Someone Pete, make that motion. Second from Paul. All those in favor say aye.
Aye.
Aye. Motion carries. Now motion to adjourn.
Motion to adjourn.
From Paul, Pete. All
Aye.
those in favor say aye. Aye. Thank you, everyone.
Thank you.
These are yours. I neglected to print them out.